we'll kick off. Obviously with so many participants, we'll do chats, questions coming through, and then pick up some of the themes for the questions at the end. In terms of that, sometimes there's some gnarly ones that are quite specific to somebody. Everyone trying to get a bit of free legal advice, bless you. So we'll probably send out an email in the next couple of days with some of those ones as well as a follow-up. So if you don't get your question answered, you might in the next couple of days. So anyway, we are here to talk about the Privacy Act 2020, and I must admit, as a privacy expert, I have been waiting for this for a heck of a long time. My slides back in 2011, I could pretty much just dust off and deliver to you, except for a few of the surprise changes that have occurred. And it's probably those biggest surprise from 2011 that are going to come through in today's seminar. So what are we going to do? Well, today is all about a helicopter view of these material changes and trying to turn the legal provisions into what actually this is going to mean for your businesses so you can start implementing the changes. And obviously we'll be doing some tips on preparing so that you can take away. So firstly, the key thing with this is that it is a brand new act. So it's not an amendment to the 93 Act, it is actually a new 2020 Act in terms of referring to it. It comes into force on 1 December 2020. And I must admit, when you do a dot compare of it, a lot of stuff has been moved around, unhelpfully for those of us who had things memorised. A number of the clauses and sections have been renumbered, which is not that helpful. But a lot of it is actually the same with some tweaks here and there. So it's not fundamentally something that's completely started from scratch. It's still information privacy principle based. The essence of that technologically neutral provisions has been continued. And I guess it has stood the test of time to a certain extent, given that the original was drafted in 1993. Our already vocal Privacy Commissioner is likely to become even more vocal, I think. This is in the context, obviously, of the 93 Act still being, I guess, taken up one notch and not as many notches as he would like, and certainly not as many notches as we probably need to keep our tick in terms of being a white status safe country for GDPR purposes. So what does this mean at a high level in terms of privacy? Well, it's a great time to really build awareness and training and a culture of privacy, and look at your practices and policies. And some of them are going to need a revamp just to ensure you are complying. And when we get to some of the larger changes contractually, some level of contractual auditing would need to be done as well. I guess this is also in the context of it not just being about a law change. Certainly, privacy worldwide, the fines are massive. Consumers are recognising that protecting their personal information is important. And so we have a culture worldwide now where personal data is something of value and should be respected. So it's in that context we are now looking at this review. One of the key things to think about as well, and to knock off a question that could occur, the new Act is still subordinate to other legislation which requires collection or disclosure of personal information. So AML, CFT, all that sort of stuff. It still trumps, and that's important. So you do still have to comply with law, and complying with law can't be excused by the Privacy Act. So one of the key changes, which I'm sure has been on most of your radar, is around mandatory data breach reporting. Now, in the current context, there's arguably been IPv5 in terms of protecting information, a voluntary ability to report and talk to the Privacy Commissioner. He's always been open to it in terms of giving advice. And in some circumstances, you should have been telling individuals if there had been a breach, particularly if by not telling them you were likely to cause more damage. That's changing now to a mandatory reporting, and that brings us more in line with many other jurisdictions, Australia being one. Now, interestingly, there's more of an offence if you fail to notify of a breach, arguably than in relation to the breach itself. Obviously, you could end up with damages from a breach, but there's no actual fine necessarily. But it is an offence if you fail to notify. So what is it that you have to notify? Some of the earlier versions of the privacy bill didn't have a materiality threshold, and obviously that wouldn't have been ideal. So what they've done is said that a privacy breach that is reasonable to believe has caused serious harm to an affected individual or individuals, or is likely to do so, is the test. And obviously there's going to be more guidance in terms of what that is. But if there is harm and it is actual real harm, then you should be considering whether or not disclosure is appropriate. A privacy breach is now quite broad. So the first bullet there on the slide is very similar to what was in the previous act. So unauthorised or accidental access to, disclosure, use, modification, destruction, loss or alteration of personal information or other misuse. So again, nice and broad and very similar to the previous wording. And it's that wording that you have an obligation to keep secure as well. Interestingly, there's a new limb in terms of the privacy breach for this purpose, and that's an action that prevents the entity, so your business, from accessing the personal information on either a temporary or permanent basis. So if you lose access and you don't have another copy, for example, that in itself could be a privacy breach. Then the question is whether it's notifiable. So a privacy breach first test has this occurred, and it's at that point things should be escalated and proper determination should be made by a team that essentially knows what they're doing and is able to make an objective call. And the test for that is around that causing serious harm. So in terms of considering that serious harm, what do you have to think about? And the Act does usefully have a list of things. If you are able to take action, obviously to reduce the harm, you should do so. And that action does play into the question of whether or not you're reporting. The sensitivity of the information, what harm could be caused, who has the information. These are all the things that should be assessed in terms of whether or not it's likely to cause harm. Is it a laptop without security to get through? You just turn the on button and all of a sudden you have all the data, or is it well and truly encrypted? And in actual fact, although we've lost a laptop, we're able to remotely erase everything. Those are obviously going to be quite different security measure determinations. Now, if you decide that you're not going to report, you have to have reasonable grounds for believing that you shouldn't. And so, again, that process when you are developing your escalation processes and policies, which it's important to do because you want your employees to be bound by this process as part of their obligations for working. It's really important that we start off with, has there been a privacy breach? Then we escalate. Because that documentation that there has been a privacy breach, but actually we've done the determinations we need to do and we've determined we don't need to report is an important element of this. So you've done your determination, you've worked out that actually you probably do need to report. And I think if we're following the example of Australia, there'll probably be a bit of an erring towards disclosing rather than not, particularly to the Privacy Commissioner. And I certainly think that they are trying to get themselves up to deal with more notifications than they've had before. I don't think they're going to go particularly harsh, hopefully, in terms of how they deal with it. Hopefully it is still going to be quite a useful and educational place to go, because that's certainly the experience we've had today. So the key here is timing. So if you have to notify, it has to be done as soon as practicable after becoming aware of a breach. And this, of course, isn't your CEO becoming aware of the breach. This is your business becoming aware of the breach. And so that's where ensuring you've got a culture, training and staff understanding that actually if something goes wrong, they need to start escalating it up, and that things are not, I guess, pushed under the table or people making determinations themselves too early that something shouldn't be escalated up. The kinds of things you have to notify are quite specific and they're listed in the Act. I haven't listed them here. Obviously, you're all able to click on that. The Privacy Commissioner on the OPC website is trying to make it an easy process as well. Obviously, they want to streamline at their end how they receive the breach reporting. Importantly as well, there are some exceptions, particularly to the notification to the individual, and those are generally if actually by notifying you're going to cause more harm than good. Now so it is quite extreme exceptions, particularly around mental health and those sorts of things, but it is important to know that there are some exceptions. There are also elements of how you disclose. Now, ideally, you tell each individual personally. Obviously, if you've got a breach affecting a very, very large quantum and actually don't have the contact details for those people, then obviously there are other methods mentioned in terms of public disclosure. So what do you need to do? What does this mean for your business? Absolutely, it's about preparing and planning. Everyone should just assume that it's going to happen at some point. You can have the greatest cybersecurity, things in place, but often it's human error. So the more training you do, the more awareness you have, the better. But at the end of the day, often it is simply somebody having a bad day. And they take an action which, if they'd just taken 5 seconds longer, they may not have done. If they double checked what was attached to an email, it may not have occurred. So the key here as well is that a mandatory data breach isn't necessarily just your infrastructure being invaded by some bad person. This is a breach across the business of either one person's or lots of people's information. And you have to think about paper, you have to think about electronic, you have to think about phone. There are multiple ways that this could occur. So having really clear guidance and training to your staff will be a key element to success here. Then, of course, you've got to have the right team in place. And a lot of the mandatory data breach reporting documents that we've been preparing or reviewing for clients have dealt not only with the pure legal tests, but also with all of the other aspects. So, do you need to bring in the police? Should you be phoning your insurer? There's lots of other sort of commercial and practical elements that should be factored in. But again, back to how do you achieve this? Definitely culture of admitting there's been a mistake, escalating it up, and training people to understand what is a privacy breach. So another one of the changes is around IPv1. And obviously, this seminar assumes that you're reasonably familiar with the IPPs as they have been for the last 20 plus years. But you'll see the change to IPv1. So if the lawful purpose for which personal information about an individual is collected does not require the collection of an individual's identifying information, and obviously identifying information includes a name, but is not limited to a name, so a key element there, the agency may not require the individual's identifying information. And this very much harps into that concept of data minimization. If you don't need to collect it, you shouldn't do so. And for many, many years, there has definitely been a culture of just collect it because we can, collect it because we want it. And that's certainly not where things are heading. You need to understand what you're collecting and why, and be able to articulate that. So this is definitely a key one. And obviously this applies to existing processes, existing application forms, existing interactions that you may have with individuals. In the context of thinking about minimization of collection, obviously if you've got a legal obligation to collect, that trumps. But thinking more about personal information as being an asset, but one that you need to be more careful of. And as part of that as well, thinking about retention periods. So often businesses will focus on the collection aspect. They may, if they're hopefully lucky, concentrate on the time that they've got the information in terms of keeping it secure, so how they manage it. But often businesses are very bad at working out when they're going to delete it or anonymize it or move it out. So retention periods and having policies for that is also important. Now, there has been some new wording come in terms of cloud computing and service providers, so that essentially the service providers that are acting on your behalf. And it's more a clarity than a change if you've been getting good legal advice. Essentially, it confirms that an agency, and that is in the sense you guys, so businesses, and unfortunately the Act uses the phrase agency throughout, and then we throw in the element of acting as agent just to confuse you, but confirms that an entity is liable where a service provider is holding personal information on their behalf. And this element, which used to be section 3, and they've changed it to another number just to confuse me, is more important than it's ever been. So previously, when you looked at your service providers or your recipients of information in any context, they were in two camps. And those camps have not changed, but the importance of them has. One is where they're holding personal information on your behalf, or they're processing it on your behalf. And by processing, I mean in the very broad sense of doing things essentially for you. They have no right to use that information for themselves or for any other person. It's just for you. Versus somebody who can use it for other purposes. So they might be providing a service, but actually the limitations on what they can do with the data is not confined enough. And that's a really important distinction when we get to IPv12. Now, the key here is that they made it clearer that to the extent you've got a transfer of data between yourselves and a cloud service provider, for example, it's not a disclosure for the purpose of the IPPs, i.e. a number 11 or a number 3 in terms of telling people who you disclose it to. So you don't have to say, we store our data on Amazon in Australia. That's not a requirement, as long as Amazon in Australia can't use the data themselves. And they are actually your agent. Again, this has always been the position. They've just come out with more clarity around this position. Key elements with service providers. Obviously, you're going to be fully responsible if they screw it up. So you need to do your due diligence. And in fact, IPv5 requires you to take reasonable steps anyway in relation to any service provider. I think it's really timely, and you will see when we get to IPv12 in terms of foreign entities, but now is a really timely spot to do an audit on your third-party agreements. As I say, this has always been the case in terms of are they an agent or are they actually a disclosure? But in the past, the distinction hasn't been as important as it is now. So what do your agreements with service providers say? Do they very clearly limit down the data usage to only on your behalf and make it very clear that it's in one camp or the other? And if they are intended to be an agent, do they then make sure that your service provider will comply with the Privacy Act as though they are you? And there's sort of a misnomer that perhaps saying, comply with all applicable laws is going to work in all scenarios, and it's not. A processor under New Zealand law doesn't actually have many, if any, obligations. It's all on you as a controller to use GDPR language. So really important to get those contractual provisions right. And if that wasn't enough in terms of why you should have it very clear where your service providers sit, we've got a new IPv12. So obviously under the old Act, we had 12 IPPs, Information Privacy Principles. We now have 13. 12 has been shunted to 13, which was the unique identifiers, but 12 is now a new slot in. The aim here is strengthening cross-border data flows. The first thing to note with this is it's not just about transferring information overseas. And obviously, it's intended to capture that. But the actual test in terms of the first gate to consider is who you are disclosing to. So it's a foreign person or entity. So yes, that could be a branch in New Zealand of a foreign entity, or it could be somebody who is actually overseas person or entity. Obviously, if they are in New Zealand, it becomes easier to comply, particularly when you feel confident that that entity is doing business in New Zealand and therefore is obliged to follow New Zealand privacy laws. So very helpful. And one would think that we will be seeing more prescribed countries as well, but at this point, that has not occurred with no indication of timing. So if IPv12 kicks in and you are going to make a disclosure, and bearing in mind a disclosure is to a third party that's using it on their own behalf as well, or for a third party. So that distinction around who's your agent is important, because if they are acting as your agent, there is no disclosure and you don't need to worry about IPv12. You need to go through and check that one of the exceptions, one of the limbs applies. As I say, prescribed country, but there aren't any yet. I wouldn't be surprised if GDPR countries, potentially Australia, although they do have some quite significant differences, particularly in terms of employment information and the size of entity that has to comply. So they aren't a shoe-in at this point, and they don't have white status for GDPR. an agency already subject to New Zealand privacy law. So as I said, the branch in New Zealand that's fully doing business in New Zealand are most likely to be covered. Model clauses, and these have finally just come out. In case you missed the announcement this morning, finally by the Privacy Commissioner, they actually slid them in just before Labour weekend, and most people spotted it yesterday. So they have finally, a little bit late, but come up with model clauses, which we'll talk about in a second. And this essentially is the concept that if you are disclosing, you have to take more steps than you used to if somebody isn't complying or doesn't have to comply with the Privacy Act. And how do you do that? You contractually do. A key element with this for larger businesses, of course, is that third parties also includes related entities. So if you've got subsidiaries, holding companies, other group companies in overseas jurisdictions, this needs to be factored in. Most of them won't be, it won't be a surprise to many, particularly if they're in Europe, because this similar sort of arrangement with having intergroup agreements is very common. One of the other exceptions, and one I think we'll get more guidance on, is around an individual expressly authorising. And this doesn't mean just sliding it into your online website privacy notice. Absolutely not. This has to be a very clear authorisation and very transparent is the indication. So you have to be saying, you know, you're giving us your data and we're going to give it to somebody who may very well not be subject to laws the same as ours or at a comparable level. So you do have to be quite transparent so that somebody is fully aware that it could go to a random place. Most of the feedback on this is that most businesses are not wanting to say this. So these are model clauses that have just come through, and if you just go through the OPC's website, it's one of the first things in terms of new release. It'll take you to a nice page that has got a number of guidance notes, the model clauses themselves, a version of the model clauses with extra commentary on them, etc. You'll find them. Now, it is envisaged at the moment that this is a standalone agreement, probably sitting alongside another agreement. Obviously we're still all digesting it and working out how we're going to implement it with our clients. The good about it, obviously it's got implicit endorsement by the Privacy Commissioner. So if in doubt, it's probably a great place to start. The aim is, of course, to cut down costs for particularly small and medium businesses, and that it is a sort of fill in the gaps in terms of the actual contractual side of it. And there are, as I say, examples of how to fill it in and guidance notes. But it also is very clearly indicated that you can't just blindly sign in and walk away. It's going to be context specific. You have to think about enforceability, obviously, in terms of who you're signing it up with. And in some scenarios, given there is still a bit of work to actually complete this, and please do go and have a look. It's been done on the basis of you don't just drop the clauses into any old agreement. You actually do have to identify quite a few things in terms of the usage, the actual information. You may find that once, in particular, we get binding schemes and prescribed countries sorted. Again, no timing indication on that at the moment. That may be an easier fit to get things across the line. So, what does all this law mean and how do you deal with it? Well, the first thing is to do that audit on where you are disclosing information. So, depending on how advanced your business is in terms of documenting data flows, you know, where are your exit points in terms of third parties? You then got to, if you are trying to get compliant as soon as you can, start thinking about whether they fall into that agency camp, in which case it's not a disclosure, or whether they do fall into a pure disclosure. Now, if you are relying on agency, it's going to be pretty important that actually not only does your team on the ground think that they don't do anything with it, but that actually contractually they can't. So various wordings that you can throw in. Hopefully there's something in the contract already. If there's not, you need to think about, particularly with foreign entities, adding those provisions in so that they do clearly fall outside the scope of IPv12. Now, if they actually are a disclosure, then it's highly likely that the document won't be compliant. The contractual obligations won't be enough, unless, you know, it is one of those more, you know, a really largely negotiated outsourcing or something may have quite advanced provisions on privacy. It might be a GDPR document with a processing addendum. The key with those ones is to confirm whether or not they are broad enough to cover New Zealand privacy law, or to cover the document enough in terms of the information. So if it's just a processing addendum for GDPR, catch there is often it will only apply if the information is about European citizens. So, some of the documents might look as though they've got some great privacy provisions. When you actually dig down, it doesn't actually apply to your situation. So doing an analysis of your contracts is a great place to start. There's a bit of work there. Hopefully, most of you have already started doing that. But if not, that's definitely where I would start. And then working out where your uplift needs to be. So another big change, and this pretty much flows sort of the concept in GDPR of taking over the world, is the concept that now we've got some clarity that the Act is intended to apply to international organisations carrying on business in New Zealand, collecting personal information, whether or not they have a legal or physical presence in New Zealand. And obviously this was, this is actually a push in the direction of, the laws applying to particularly online businesses, the likes of a number of platforms and social media, or businesses who are simply doing a lot of sales into New Zealand. I think there'll be more clarity coming around, hopefully, around the test. Obviously, it's a similar language to the Companies Act doing business in New Zealand, and there is commentary and case law around that. But certainly, I would be taking a reasonably conservative approach if I was a business doing an entity doing business in New Zealand and complying. And it's not majorly hard if you are, for example, in a GDPR country to comply with New Zealand legislation, because their standards are so high, but there will be some jurisdictions where it is a little bit harder. One of those main changes with Australia, being our closest neighbour, is around the employment law. So employment records generally not being covered by Australian privacy law, but being covered here. So it's those sort of, particularly if you're in an international business with headquarters in Australia, understanding those differences is going to be key. As I said, a lot of the IPPs haven't changed too much. One change, though, is IPP3, and that's the one with the checklist of disclosures in terms of privacy notices. There was an exception where an individual has authorised that you don't actually have to tell them. So essentially, there was an ability to contract out with an individual of IPP3. Must admit, I hardly ever saw it. It has been removed. You no longer can opt out of making privacy disclosures. And there's been a removal of the word directly. So notices needing to be provided has been broadened from collection directly from the individual to simply collection from the individual. And again, I think this is probably more a clarification than a really big push. And certainly the commentary and parliamentary discussions around this has indicated it's not meant to be a big change. This clarifies things like video cameras, other means of collecting information from an individual, but maybe not directly from the individual. So that they haven't moved as far as GDPR, for example, where not only is there a broad list of things that need to be disclosed to the individual when you're collecting from them, but there's also a list that you have to disclose to an individual when you collect information from a third party about them. So at the moment, we haven't taken that next step, and so we are still further behind on IPP3. But what does this mean? Well, certainly consider notices at less direct collection points. So there obviously has always been an obligation to ensure that you've got signs up where cameras are, and that people are put on notice in terms of collection at appropriate times. I would go back and double check that, really make sure you are taking a wide view of collection and that appropriate notices are being made. And potentially update your privacy notices, because a lot of privacy notices are those particularly those that were drafted and then sort of have sat on websites for a long time, often only for a start deal with website, even though they're referred to as being privacy notice across the business. And then if they are have been updated to be broader than just the website, they often are just thinking about customers. And you actually need to think much broader than that about your interactions with individuals across the entity. And this is not a strict change to the wording of the Act, but certainly a change that I would be expecting, and that we've had plenty of commentary and the Privacy Commissioner will be hot on. And that is what is now expected in terms of taking any steps that are, in the circumstance, reasonable to ensure that the individual concerned is aware. So this leading words for IPP3 and notice. You definitely shouldn't be bearing disclosures about how information will be used just in your privacy policy online, and not bringing things to people's attention, particularly where something is not what they would expect. Certainly don't just have your website with your hyperlink at the bottom, particularly where you can't even see the hyperlink because the screens are now not set up appropriately. You have to scroll down quite a lot to get it. So thinking about your user experience, referring to your privacy notices or making specific disclosures as appropriate, to really be reasonable about making people aware of what you're doing with their data is what is now expected. Again, not a regulatory change in terms of wording, but certainly in terms of what is reasonable. Another reasonably significant change, and one that probably helps with getting some time and budget to work in this space, and often that's what is needed, is that although the baseline fines have not increased significantly, so a baseline fine under the Privacy Act is $10,000, and whether or not that is going to apply to one person's breach or multiple will be played out. But one that has been made very clear is around the Human Rights Review Tribunal, and that is essentially where an individual can go in terms of damages. And there have been, in the past, a number of damages. None have really gone up to the 350K mark, which is where they could go. But certainly around that sort of the 50 to 100, you do often see a damages awarded, often for hurt and humiliation, often in the employment context, but also in some other contexts as well. They've made it very clear that actually you can now bring a class action to the Human Rights Review Tribunal, and that each member could claim up to $350,000 in that space. So it's a very clear indication. We don't often see it in legislation, but this is where they are sort of heading in terms of, I guess, raising the bar on what the potential claims are and making it easier for people to make those claims. So if you did have a very large breach affecting a couple of thousand people, that could and there actually was damage and they could prove it, that could end up being quite costly. Other key changes, and if you're familiar with the previous Act, it was certainly, the Privacy Commissioner was certainly a toothless dragon. Now they do have more power, and as I say, I'm still hoping that there'll be a nice place to go and actually get positive and useful feedback so that people can take the steps they need to comply with the obligations. But in the past, that's pretty much all they could do. So now they can actually issue some compliance notices. So if they are hearing things or people are complaining, they can actually issue notices requiring an agency to do or prevent doing something. And these are actually then enforceable at the Human Rights Tribunal level. So certainly if the Privacy Commissioner comes a knocking, I would be taking it a lot more seriously than potentially you may have in the past. As I say, there are some new criminal offences. Again, fine only up to 10,000. One of those is if you mislead an agency in a manner that will affect another person's information. So that's actually quite useful. So that's around that phishing, actually, individuals making it more difficult for businesses. So that is a useful one. Another one though, and hopefully none of you are, in businesses where this would occur, but certainly having policies which make it clear that this is unacceptable. So if somebody does make a personal information request, so IPv6, in terms of wanting to essentially get access to the information that you've got about them, whether it's an employee, whether it's a customer, supplier, if you knowingly destroy those documents where a request has been made for it, that in itself will now be an offence. Another area where we often end up having to advise, and there's a lot of grey, is around access requests, generally, in terms of what would fit within an exception, so you don't have to provide it, how much effort you have to go to in terms of fulfilling a request. Those are often the grey areas, and the Privacy Commissioner can now issue a binding decision in this space. It can be appealed to the Human Rights Review Tribunal if you disagree with it. But I would look at this from a business perspective as actually being potentially quite a useful thing. Obviously, at times you're not going to want to give information out, and you may want to err as a business on sticking to your guns in terms of the opinion you've got. But in others where actually you just want to understand what you need to do so that you can comply, this might be a useful avenue. And another reason why you'd certainly want to answer if the Privacy Commissioner comes knocking is that they are getting much better investigative and information gathering powers. So obviously, if we all think about the Commerce Commission and the phrase dawn raids, they have a lot of power, and certainly having policies and procedures about how to deal with them is important. Similarly now for the Privacy Commissioner in terms of complying with what they want and actually doing it. Timeframes are shortened and penalties have gone up. So those are the main changes. Obviously, there's a number of others that are the smaller in terms of the main highlights. What do you need to do to get your business ready by 1 December? First up, I would think about a data breach response plan. As I say, the best ones are ones that actually are usable. You want them to be accessible to staff. You want them to be part of your practice and procedures so that employees are obligated, hopefully through their employment agreements, to actually follow through on them. Again, the time for a data breach response starts from when your business is aware, not from when your CEO is aware. The next space I would be playing would be around your agreements. As I say, IPP 12 now in terms of foreign entities, but also obligations anyway in terms of your service providers. Doing that first audit, I guess, of whether they fit into agency or whether they are pure disclosure. And then in terms of the risk profile for them, are they foreign entities? And working to ensure that you are uplifting those as appropriate, either as soon as you can or as appropriate in terms of the risk profile. That obviously dovetails down into that next bullet. If you are sending information offshore, particularly looking at the definition of foreign entity, so look at who the other party is. Obviously, the offshore ones are going to be your first obvious indicator that perhaps it's a foreign entity, but certainly pulling the contracts out of the drawer and working out who you're giving the information to. With that, think about your group as well. It's having actual agreements between intergroup is important. So just having a policy that everyone will look after each other's data, generally considered not enough. You do actually want contractual obligations on those third-party entities to comply. I would take now as a great time to review your existing privacy practices and policies more broadly. So updating your privacy notices, there's an absolute move to increase transparency. Although the list of what has to be disclosed hasn't materially changed, the move to a user experience, ensuring that actually it's easy to read, that it is clear about what people actually are doing with their data, and it hasn't been updated for some time. Probably it hasn't, and now's a great time to do that. You also dovetail that up into that audit that you're doing of your service providers and disclosures. So once you work out which ones actually are disclosures, have they all been listed in your privacy policy? Other policies and procedures which get triggered for change. We didn't cover off the access requests changes. A lot of the high level of the access request stuff hasn't changed, but some of the procedural aspects have changed, and certainly the clause references and the exact wording has changed and been moved around in the Act. So if you do have a policy and procedure in terms of how you respond to access requests, those documents should be updated for the new language and the new requirements. And if you don't have one, think about getting one. And as I mentioned through today's seminar, to comply really is going to rely on not just you at your desk, building up that privacy awareness and culture of compliance in the space, and being able to escalate when things don't go right. So having a culture of, as well, I guess, no blame culture. People think they're going to lose their jobs by admitting that they've done a data breach, then you're not going to hear about it. In terms of, again, complying with the Act, ensuring that you're future-proofing your business for more potential changes, and I'd be very surprised if we don't see a Privacy Act 2.0 coming out. If it's based on the previous wait, it'll be many years, but certainly we are so far behind still that I wouldn't be surprised if we should be thinking towards GDPR kind of standards when you are doing new systems and processes. Doing privacy impact assessments, they don't have to be the biggest things sliced bread. Certainly I've seen 100, 200 page documents for massive, big, particularly public procurement, where data is the key. But they don't have to be quite that complicated. They can be quite simple, but getting people to turn their minds through the business to this as being something that they should be thinking about is really key for building that culture. Integrating privacy into your business processes. So don't just think about privacy as something as between the business and customers. So, your HR team, how employees deal with each other, that all links towards the culture as well as compliance. Obviously, a regular review of your processes and policies, and now is an excellent time if you haven't started, and reviewing your contracts, making sure that your precedents for particularly procurement, but other precedents as well, have new and fit for purpose clauses in them. And obviously we are here to help if you need that. And I'm sure your regular lawyers would also hopefully be on top of this, but certainly we're very busy at the moment in the space, both on contracts and process and policies. Training and education, absolutely key. We've got Privacy Week kicking off next week. So the Privacy Commission has lots of posters and they like to make a hoopla. If it's not too late, think about doing something for Privacy Week, which is next week. And really it is around that privacy protection culture, where people are making the right decisions because it is actually top of mind. As I said earlier, mistakes and breaches, they're not necessarily at that cybersecurity fall down level. It's not necessarily a great big hack that gets your data. It could be a phishing, one email that comes in and somebody just doesn't take that 2 seconds to think. Some of them are very, very good. Some of them look as though they come from Nigeria, but some of them actually are very, very savvy. Do tests on your staff. We do them here across the Dentist Network worldwide. Regularly, we throw out ones to see who's going to fail. And those people, they're not thrown across the coals, but they certainly are given some more education in terms of what to watch for. And when you've got staff that are working remotely, that's another area where you have got a slightly higher risk profile. Think about your remote working in terms of not only the security of the systems that they're using and how they access in, but that fact that they are more likely potentially to respond to a phishing that might look like it's coming from a colleague. And usually they might just wave across to the colleague across the hallway and double check it, but you're in different locations. So that is largely what I wanted to cover today, and I'm sure there have been a few questions coming through. I'm just looking over to my lovely Carla here to see if there are some. I know, apologies, because I have been concentrating on talking to you, I haven't seen them come through until now. Any guidance on what sensitive means? No, there isn't any. I think that sensitivity, if we look at Australia, they have a beautiful list and they have different thresholds for what is sensitive. This was just a question about whether there's any guidance on sensitive. And I mentioned that in the context of assessing damage and assessing whether there's a likelihood of harm to an individual. It's the only place it applies. Arguably, sensitivity of data should impact the reasonable tests throughout the Act. So if you have got more sensitive data, whether it be health, credit, sexual orientation, marital status, there's a large list in Australia, that would be a good place to start, but I certainly wouldn't look at it purely from that list. It's largely to do with what you can do with that data in terms of damage, and then from an individual's perspective, whether or not they would be hurt or humiliated if it was disclosed would be my starting points. So there's another interesting question through here. What's the situation if two separate entities are required to report to the same individual on the same breach? Is it the same as in the AU in Australia, where the entity with the closest customer relationship makes the report? So that hasn't actually been fully clarified at this point. Arguably, the obligation would be on each entity that has had a breach. Certainly doing it in a concerted way would make the most sense. And I would expect that we'll get more information around what the expectation is in that. If I was advising at this point, the obligation would be on both entities to ensure that the disclosure is made. Then how that's done, I think, it should be done in a sensible way. So I'm just whipping down through some of these questions here. It's not touchscreen. Actually, I've just got this one going. So if a cross-border disclosure is within the same group of companies, does IPP Clause 12 still apply, or is this under an exemption? No, it does apply. So a really key aspect here is that third parties includes related parties. So each of you are individual, and you do need to consider that. Intergroup agreements are probably going to be the easiest way of dealing with it. In some cases, you may have intergroup agreements that are GDPR compliant, but they won't be New Zealand compliant. So tweaking those might be a place to start. Or obviously, we've now got the model clauses, which OPC has issued. But yes, certainly third parties does include related parties for purposes of throughout the Act, but certainly IPP 12. This is an easy one. Is it possible for the slide back to be circulated? Absolutely, we will circulate that afterwards, along with evidence that you've obviously attended for CPD points. Very good question. Now, I must admit, I haven't put that much thought into this. With the model clauses, are they still usable post-scrims? Now, I think the key thing with the GDPR and everyone thinking that the model clauses were the be-all and end-all and it falling down is that that's how they've been presented, as in use these, you'll be safe. Using the model clauses in New Zealand is not the only story. So you still have to do due diligence. You still have to think about whether or not the country itself is you are going to be able to enforce the contract in the country. So yes, certainly it's a good place to start. But those guidelines around the fact that it's not, just completing it isn't everything you must do is clear on the OPC side as well. Sorry, scrolling through here to get some things. As I say, we will answer some more by email if required. So keep the questions firing through. So another question here. How will the New Zealand Privacy Act from 1 December differ from the current Australian Privacy Act? So a couple of the key differences remain in terms of Australia's scope not being as great as ours or as great as the GDPR officials would like. So one of them is around employment information. So a number of employment records fall outside the federal privacy legislation in Australia. And a lot of the privacy work in terms of assessments, particularly for data access requests in New Zealand that we get, is in that employment space. So over in Australia, they don't have that, we could describe it as a problem or an issue to deal with. Another one is which entities in Australia have to comply with it. So there's a threshold. And I haven't got it in front of me. I'm tempted to say 3 million Australian revenue, but don't quote me on that. There's a threshold, at least, for the revenue of a business. So very small businesses don't need to comply. So those are two quite large gaps, and they've been there for a long time. Obviously, there's distinctions as well, though. So theirs is principles-based. The principles aren't quite the same in terms of the language, but often you end up with a very similar result. The mandatory reporting test is slightly different in terms of timings, what you have to say, the forms, and the test itself, although, again, often you're going to end up pretty similar. Hopefully that answers that question. How should this is an interesting one. How should the customer information gathered for contact tracing COVID purposes by businesses be handled? Very carefully, I would think. And it should only be used, this is a key one, only be used for COVID tracking. So if you've got a business now that has been diligently, with those lovely forms, been collecting names, addresses, phone numbers, and all the rest of it, that should not, repeat, not be used for marketing. Yeah, that's probably my biggest guidance on that one. After a certain period of time, I think we need to work out whether it should be destroyed completely or kept for evidence. And I haven't looked at that. No one specifically asked it, but it's a very good question. There is an obligation to maintain, particularly through certain periods of the levels for businesses. So whether they should keep it for a certain period very securely to show that they have done it. Obviously, in terms of the use of it, with the 14 days, in terms of somebody's being possible to share it, after a certain period, you would, in theory, be able to destroy it, but for proving that you have it actually collected in the first place. So people asking about breach notification plans. So we are certainly supplying those to our customers, modified forms. So if you are needing those, we are offering those as a service and stylising those in. But certainly more commoditised than they probably have been in the past, if that's the sort you are after, or a more stylised one as well. Probably a final question looking at time, that's quite an interesting one. Again, if there are some questions I haven't answered, I will get one of my team to provide a quick response and circulate those out as well. But can you give some examples of privacy breaches that might occur within organisations? Examples of staff for education purposes. Well, I think, yeah, the first thing to get people's heads past is that it's not often, somebody bad sitting in some other country that manages to get through your system and pull down the data. That certainly makes the headlines. It makes the headlines because it's usually credit or very sensitive information, and it's usually big numbers of affected individuals. And overseas, obviously, there are massive fines for the breach itself. And again, that's a distinction here in New Zealand. At the moment, there won't necessarily be big fines for the breach itself, although there may be damages in terms of that human rights by the individuals themselves. So you get more trouble again in New Zealand by not disclosing, potentially. So I think the key is, and we've actually done a number of seminars on this in the past, with examples from the privacy website. So a lot of it is around mistake. It really, really is. It's about somebody responding to an email in a way that they shouldn't have, attaching the wrong Excel file. Attaching an Excel file that has hidden columns is one that was quite big for a while. So, not double checking that what you've attached doesn't have information that you don't realise is there. That was an Islington Borough one where unfortunately there was very, very sensitive information in those hidden columns, and it was loaded to the internet and kept there for quite some time. So it really is about making people aware that personal information is in many forms. It's around them every day. And for those people who do have access, you can either slow down their job slightly by having another check that comes in, with a little pop-up. I have heard of that occurring in higher risk. You're saying, have you double checked what's attached? Or that can obviously slow people down, which may not be what you want. But really making them aware that it's usually a mistake. And then it's things like your device. We've got lots of devices now, we're all working remotely. We do want our staff to take the devices home. That work anywhere, anytime is definitely where we're heading. And that in itself raises risk. So making sure that paper is secure, destroyed securely, not just thrown in the home rubbish bin, through to, keeping their device locked. Most businesses, I think, at the infrastructure level have got multiple authentication to get through to systems that have data, but some of the smaller businesses don't, and those smaller businesses are probably in less good shape for that work from home security. But as I say, even the ones that are larger businesses, there is that risk around responding to a phishing attempt or phone or email with people wanting information, and not being next to a colleague. You don't do that quick sounding board that you might otherwise have done. So I think with 2 minutes to spare, I'm going to hand over to Grant to round out. As I say, we will do a follow-up email, and we will circulate the slides, which will also show that you have been here today for your CPD points. Hopefully you've all got something out of today's seminar. If we can be of service, as I say, we have a number of commodity products as well as stylised, working with our clients to get you across the line. And hopefully this has been an indication of where you should start.
Kia ora. Hey, look, Hayley, just on behalf of ILANZ and the ILANZ committee, I just wanted to say a big thank you to you. What an excellent session, practical, not too down in the detail so that our eyes glaze over, but you've given us a really good sense of the contours of the new Act. You've demystified it for us, and I'm very grateful for your time. So just a big round of applause. Raise your hands on the call if you're really happy to have been a part of this session. And I just wanted to honour and acknowledge Kensington Swan, now Denton's Kensington Swan, just for your ongoing support for ILANZ. COVID has been quite a challenging time for us as an organisation and a section of the Law Society. So we are very grateful for your ongoing support. So thank you, and please pass on that thanks to the Denton's KS team.
Excellent, thanks Grant. As I say, we'll send out the follow-up, and if you do have any extra burning questions, feel free to give me a bell. Have a great day, guys.